Welcome everyone, and thank you so much for joining me. My name is Lynn St. And I am an estate and elder law attorney. What we're going to be talking about today are the 5 life events and how that impact your estate plan. Now, a lot of people think that once their estate plan is in place, then they're done. And frankly, if you have an estate plan in place, congratulations. Great job on doing that work. It's so important. Then people, though, might not realize that once you have your estate plan in place, things in your life might change. So we're going to be talking about 5 life events that occur naturally that require at least some thought as to, hey, do you need to change up your estate plan? As a general rule, an estate planning attorney will suggest to you revisit your estate plan every 5 years. That's kind of just a rule that is in place. Sometimes in 5 years, nothing needs to change, but sometimes maybe you've done your estate plan and something has happened in the next year or 6 months requiring at least a revisit to what your estate plan looks like. So we're going to be talking about that today. We're going to be talking about major life events such as a move to a new state. That would be one of them. Or maybe there's changes in your health or your family's health. Maybe there's a birth, a marriage, a divorce, a death. All of those things mean, let's take a look at your estate plan, see if anything needs to be changed. Third, well, health was a major event that I just talked about. Fourth, what if we have a change to your assets? Maybe you buy a new home. Maybe you've sold a home. Maybe you've inherited. What needs to be looked at? And then, of course, any changes that impact your decision makers, those are the people that are your personal representative or they're also called executors, or your trustee or your decision maker under your power of attorney. Those are called your POA or your attorney in fact. So those are the things that we're going to be talking about. Please feel free to type in your questions. You can type them in the chat box, type them in. I will do my best to answer all of your questions today. All right, so you're going to be no surprise as we go through this. One of the things that I'm going to be saying more than once is, we'll talk about the changes, but if you yourself have such changes that have occurred in your life, what do you do? When people have an estate plan in place, they could have done it themselves online, downloaded forms, or perhaps you went to an estate planning and elder law attorney. If you've done your own estate plan, then you do have forms. But what I think is really important to understand is that an estate plan isn't just documents. What really makes an estate plan a good, robust, workable plan is that you've got the counseling, you've had some professional guidance to help you understand what is involved in an estate plan. How does your personal situation impact what your documents should look like? So as I said, no surprise, one of my recommendations if you've experienced any life-changing events is see an estate planning and elder law attorney. Now, how do you find a good one? Well, in this age, we know everybody does their Google research. Do your Google research. See what what kind of comments online or what the reviews are for the attorney. Of course, talk to your family or friends. See if they've had a great experience with an estate planning lawyer so that they can refer you to that attorney. And if you're looking for an estate planning attorney in somewhere out of state, maybe you're looking for a family member, or maybe you've moved to a new state, a really good resource is the National Academy of Elder Law Attorneys. And so their website is naela.org. And we'll type that into the chat for you, naela.org. That is NAELA, and that is the National Association for Elder Law Attorneys. So, there's never any guarantees that the person you're going to meet with is going to be a good fit for you. But just like any other professional that you're looking at working with, do your research, make sure you're comfortable with that professional that you do hire. All right. move to a new state. You have relocated and now you're living in a different state from where you did your estate planning documents. Do you need new estate planning documents? Well, the question is it depends. See, estate planning documents themselves, the documents will be good. If they were good in the state that you lived in, let's say you lived in California and then you moved to Washington, and your documents from the state of California will be honored in the state you move to. For example, if you move to Washington. So they're legally effective, but the question really is are they the right estate? Is it the right estate plan for you? Because legally effective documents are kind of academic. They don't accomplish what you want. You need the estate plan that accomplishes what you want. So let me give you an example. If you live in California, you likely have a revocable living trust. And the reason for that is that in California, probates are very expensive. They charge a percentage, legal fees are a percentage of your estate, as I understand it. And so very, very commonly, Californians will have what's called a revocable living trust. The idea with that is that that kind of estate plan will avoid probate. So you live in California, you have a revocable living trust. You move to Washington, you buy a house here in Washington. Probably when you bought a house here in Washington, the title to the house wasn't in your own names, but put into the trust. So everything feels right. I mean, you have the same documents, everything seems to be working. Should you have any changes to your estate plan? It depends. Your situation may be such that a revocable living trust and avoiding probate is the right thing to do here in Washington. In Washington, though, need to keep in mind that our probates are very simple, nothing like California's. So in Washington, we're more likely to set up an estate plan that does not have a revocable living trust component to it, unless there's a good reason to do so. So if you move from California, let's say that you have significant assets, let's say you have long-term care insurance, let's say you have property in multiple jurisdictions, a revocable living trust plan is probably a good idea. Well, let's switch it around a little bit. Let's say you move from California to Washington, you have your revocable living trust, and all you have is your one house and maybe your retirement account and maybe, other investment accounts. And you and your spouse, maybe you don't have long-term care insurance. In that situation, with the guidance of an estate planning and elder law attorney, what we're going to be exploring is, what are your goals? What are your concerns? A major concern often is that people are worried that their long-term care expenses, if they have any in the future, are going to eat up all their money. They're also concerned that if they die first, they don't want to leave their spouse with nothing. They don't want to leave them in a situation where all the money potentially could be spent down on long-term care costs. So commonly under that kind of scenario, we would say, no, the revocable living trust, while it's legally enforceable here, probably isn't a good idea for you here in Washington. The reason for that is, in the state of Washington, in order for one spouse to protect their assets for their surviving spouse, they have to do it through a will. So let me explain what I mean by that. So in Washington, let's say the couple is concerned, maybe one of the couple has Alzheimer's or has a diagnosis, and they're going to be needing possibly long-term care. So in Washington, we would want to be looking at having a will, and in that will, it has a special kind of trust that protects assets for the surviving spouse. And if we have that kind of estate plan, which is what Washington requires for us to protect assets for the spouse who survives, we don't want a revocable living trust. We want a will. So how you would know that, really the only way that you would know that is that you go meet with a new lawyer in the state that you've moved to. So if you move from California to Washington, yes, you should seek out an estate planning and elder law attorney. Otherwise, how would you know that you are giving up one of our best planning options here in Washington if you don't? So that's just one example. Let me talk about powers of attorney. So powers of attorney are the document that you sign while you're alive, and it says basically, if I lose the ability to manage my own affairs, be in financial affairs or health affairs, then I'm going to designate somebody to speak for me. I'm going to designate a trusted person who knows me, who can handle my finances and my healthcare decisions. So if I were to do that, then I would probably designate my husband to be in that role. And if he couldn't do it, then I designate my children in successive order, my adult children. So with a power of attorney, you're saying who would step in and make decisions for you if you can't yourself. If you don't have an effective power of attorney in place and something happens to you so that you lose the ability to make your own decisions, if you don't have a good power of attorney, then the court steps in, you become a ward of the state, and the state is in charge of all those decisions. So really, that's not a place that we want to see anybody be, is in a court-ordered guardianship. So let's say you have documents in California, you move to Washington. Legally, they're effective here because you've done your work, you've done your estate planning, you met with an attorney, you have good durable powers of attorney, documents in place, and you lose capacity. Is there going to be a problem? Well, again, it gets back to technically your powers of attorney should be accepted by any financial institution. But practically, and this is where we get into the rub, this is where the problem is that a financial institution or some business in this state, in Washington, might not recognize or be familiar with what an out-of-state power of attorney document looks like, and they will reject them. So there's also financial institutions that say, hey, this is an old power of attorney. This is beyond 5 years old. We are not going to accept it. And the problem with that is the reason that the power of attorney document is in place is you've lost capacity. Somebody is acting on your behalf. So they're dealing with the fact that their loved one has lost capacity. And now they're being stymied by the financial institution that says, oh, we won't accept it. I, as a lawyer, will say it's legally enforceable. And then they'd say, well, then what do we do? It's like, well, then we have to go to court and require and get a court order against that financial institution to accept it. Whenever you need to go get court order to enforce something like a power of attorney, you know that that's not the best situation. It is far better when you move to a new state, you move into Washington, or you've had your estate planning done in Washington and you move somewhere else, to simply contact an estate and elder law attorney, and they'll take a look at your documents and they'll tell you basically what the lay of the land is in the area that you've moved to. So you may need new powers of attorney drafted, you may need a new will drafted, you may need other estate planning documents drafted, and you're going to go, darn it, I already paid for that. Yes, you did. Professional services and estate plans are one of those things that do need to be revisited. And if they're to work effectively and serve you, then you may need to pay when you move to another jurisdiction to have somebody who's an estate planning lawyer with expertise tell you, what needs to be revised or changed in your estate plan. So moving to a new state is an important reason to revisit your estate planning documents. Next, birth, marriage, death, and divorce. So any of those events is going to be a situation where you should pause and say, do I need to change my estate plan? So let's talk about a birth. Congratulations, you're a new parent. You have a new baby. That's, happy times in people's lives. From an estate planning perspective, it's also something where I'd be saying to the new parents, well, do you have estate planning documents? Have you put into place something that says who would be the guardian for your minor child if both parents have an accident, if both parents are either rendered incapacitated or killed? Nobody likes thinking about these things. Unfortunately, that's what estate planning lawyers think of all the time is, what if this happens? What if that happens? The reason it's so important when you're talking about, a young family and minor children is there's the proper place to say who you want to be the guardian of your minor child if you can't do so. And that place is in your will. The court will follow what the parent's wishes are. If in your will, you say that I want so-and-so to be the guardian of the minor child or children, then the court likely will appoint that person. If you haven't done that and that situation were to befall your family, then it is not that uncommon that people will disagree, the survivors will disagree, and then there will be a tug of war over the children, which is a terrible situation. So if you are a new parent, then absolutely you need to have a will where you designate who is going to be the guardian if you and the other parent can't be. Okay, let's talk about if you're newly married. So same thing, if you are newly married, you need to make sure your estate planning documents reflect that. So if you're newly married, and even if maybe it's a later in life marriage, and you and your new spouse are not even thinking about things, maybe you even try to keep everything separate. Washington and Idaho, we are community property jurisdictions. So once somebody gets married, income is both of their incomes from wages and earnings. How you treat your assets really reflects, those are probably going to be community property assets if you commingle them. So if you get married and you have old estate planning documents that don't recognize your new spouse, what happens when you die? Your new spouse may be entitled to up to $125,000 from your estate, even if you and that spouse had agreed, no, you're not going to get anything. So that's something to be aware of. That's a statutory provision we have in Washington. If you're newly married, then it's really important to revisit retirement plans, because there is the possibility, if you marry and you're working, that upon your death, your 401k, for example, must pay to your spouse. You've been married for 6 months, and maybe it was your desire that your retirement assets go down to your kids or to your grandkids. But if you haven't changed your beneficiary designation to reflect the fact that you're newly married, it is very possible that that new spouse gets your entire retirement account. If it's going to pay, and that's just by the terms of the retirement plan. It's nothing you did. It's just that some plans say an employee, their retirement account will go to their spouse, period. Unless the spouse consents and signs off to, oh, I don't want that retirement account, it can go down to the kids or the grandkids. So retirement accounts, beneficiary designations, it's a huge trap for people who don't understand how important it is to update the beneficiary designations. So you can talk to your HR department, but that's just one aspect of what happens when you get married and what spousal rights may be. So definitely newly married absolutely requires seeking the help of an estate planning lawyer to help you with that. So other things. Let's talk about the next major life event that can happen. It could be a death in the family. So what happens then if perhaps somebody who you had designated to inherit from you dies, or a spouse dies, or someone dies? Anytime there's a death in the family, it definitely is important to go revisit your estate planning documents to see how that death impacts what your estate plan was. Again, that's something that getting counseling and guidance from the estate planning and elder law attorney will really help you out with that. Let me give you an example of how it might make things simpler. Just because I say revisit your estate plan, that doesn't mean it's to complicate it more. It could be to simplify things more. So let's say that your estate plan had been for you and your spouse to protect each other with assets that would pay through the will to a supplemental needs trust when the first of you dies. Let's say that what happens then is one of the spouses dies. And then when one of the spouses dies, perhaps the one who is surviving doesn't need any kind of asset protection, nor do any of their kids. We might revise the surviving spouse's estate plan now to say everything just goes outright to the kids, no need for a probate, everything is pay on death or transfer on death. So prior to that situation, when there were two spouses, there may have been a good reason and it would have been desirable to have a probate. But now, perhaps with one spouse gone, there's no reason to do any asset protection at that point for the kids. So we might revisit the estate plan to simplify it rather than to have a probate. For example, do a transfer on death deed on the house. So there's all sorts of what could be done. I'm just trying to give you some examples to give you some context. So revisiting the estate plan once there's been a death is really, really important to do. Let's talk about a divorce. So maybe you are now divorced and you have a divorce decree, and the divorce decree goes through and it says, well, you know, this spouse gets this assets, this spouse gets those assets. Great. You think, hey, I'm done. And maybe you just didn't even think about the fact that, well, should you change your will? Maybe your will said everything goes to that person. The state of Washington has some laws that I think are really smart. The state of Washington has a law that says, if you're divorced, we don't think that you want that ex-spouse to inherit under your will, or to get the life insurance that, you know, that they still are on the beneficiary designation. And that's probably right. So the state of Washington has this default provision that says, hey, if you're divorced, we're going to treat that ex-spouse as if they're deceased. So that's to help ameliorate some of the problems when people don't change up their estate plan after their divorce, which is all well and good. But remember those retirement accounts I was talking about before? There is a federal law called ERISA, and it is not governed by state law. So what that means is, if after your divorce, you don't remarry, so you're single, and you don't change up the beneficiary designation on your retirement account, so it still says pay to your ex-spouse when you die, there's no state law to. So what that means is that ex-spouse gets the rest of your retirement account. They already probably got half when you had a divorce. Now they get the rest of it, and it does not go where you wanted it to go. So that is a very unpleasant surprise people encounter. So don't let that happen to you. Talk to an attorney. Make sure that your assets that you've worked so hard for go where you want them to go. You know, you might be asking yourself, okay, well, Lynn, this is really interesting and I'm kind of getting it now, but I'm not going to remember this and I'm not going to remember all these details. And you shouldn't. There is no way that you could remember all of these things that you have to do. I mean, I'm hoping that I'm sharing enough information with you that you can go, okay, well, that's happening in my life or that's not. But, you know, in a year or 2 or 5 years, are you going to remember this? No. But what I do hope you remember is that you remember that we talked about if there are life events, life circumstances change, should you change your estate plan? You can say, I don't know, but I think I should talk to somebody who does know. And that might save a lot of grief, a lot of problems if you weren't to go back and see that lawyer. In other words, I said too many double negatives there. Please go see an estate planning lawyer to help guide you through that, because you're not expected to remember all this. Nobody can do that. All right, number 3, big life changes. Changes to your health. This is actually the one that most people do get. They understand that if their health changes, and usually what that means is if their health declines, they should take a look at their estate planning documents again. So what do I mean by changes to health? As an elder law attorney, we are frequently helping people plan for long-term care expenses. Look at what government benefits might be able to defray the costs of long-term care expenses, pay for the long-term care expenses. So if you get a diagnosis that is one that means you're likely going to need long-term care, like Parkinson's or some form of dementia or Alzheimer's, absolutely see an elder law attorney, revisit what your estate planning documents look like, what your estate plan is. There are, and elder law attorneys are well aware of this, estate planning documents that will protect assets. They'll protect assets for your spouse, for your family. There is a lot of planning that can be done. And frankly, it all depends on what your circumstances are. What's the best thing for you? What do you want? What can we do that won't jeopardize the care that you would receive? It's just impossible to go into any details on that. But what I do want you to understand is that an elder law attorney can walk you through all of those options so that you're taking the steps you can take to protect yourself and your money. It's just that people don't know what their options are. And that's why an elder law attorney is going to be so important if you do have a change in health or a diagnosis that says you're probably going to need long-term care. So one of the things I mentioned, Alzheimer's, it's really important that those estate planning documents be in place as soon as they can be. So what I mean by that is, let's say that in the couple situation, there's a diagnosis of Alzheimer's, but the couple doesn't do anything. And by the time that finally they reach out to an attorney to help them, it could be too late, at least with respect to the spouse who has the Alzheimer's diagnosis. In order for estate planning documents to be prepared by us and to be signed by the client, that client needs to understand what they're doing. They don't necessarily need to know every detail, but they have to have what's called legal capacity. And if folks wait too long and it's a dementia situation, it might be too late to take action to put those documents in place. It might be so late that not only are the assets lost to long-term care costs, but then there's a court-ordered guardianship, which happens even in a spousal situation. So don't wait too long. I mentioned previously that in a will, that there can be a special kind of trust that is put into the will to protect assets for the spouse. So for example, let's say that one spouse does have Alzheimer's. We might do an estate plan where we put all the assets into the name of the well spouse, the one who does not have Alzheimer's. And why we do that is that if the spouse who is the well spouse dies before the spouse who has Alzheimer's, then all of those assets of that couple can then pass through probate, fund the trust for the surviving spouse. Assets that are in that trust for the surviving spouse are not counted as belonging to the surviving spouse. So what that means is, let's say that that surviving spouse does need long-term care. Well, a single person, Medicaid says, can have $2,000. That is an impoverishment standard. But under the situation I just described, that surviving spouse can have not only $2,000, but everything that was this couple's assets, because all of it paid to a trust for the surviving spouse. So let's say this couple had $500,000 in assets. So that surviving spouse with Alzheimer's can actually receive government benefits, Medicaid long-term care benefits, even though they have $500,000, everything that this couple had ever earned, because it's in the right kind of trust, a trust that the will created for that person. So that's just one example of why it's important to do good estate planning to protect assets. This kind of a trust that I was just describing, sometimes it's called a supplemental needs trust, sometimes it's called asset protection trust. What's important for you to understand about it with respect to the spouses is it must be created by a will. It cannot be created by a revocable living trust. So it has to be a will to protect assets for the surviving spouse. That's what Washington law says. This type of a trust that's created by your will can also benefit not just a surviving spouse, but anybody who might need asset protection. Maybe they have lifestyle issues. Maybe they can't manage their money. Maybe you're worried that that beneficiary might lose everything in a divorce. Or maybe they're simply a special needs child or a special needs grandchild, and they actually are receiving needs-based government benefits. They can still receive all of those benefits. And again, remember, the standard for somebody who's single to get benefits is $2,000 in countable assets. So you would not want your grandchild with special needs to inherit outright, or even to a minor's support trust. It needs to go into this supplemental needs trust, because that's the only type of trust that you can create for your child or your grandchild or other beneficiary, where the money doesn't count against the person who's getting benefits. So, you know, there's a lot of planning that you can do if you have a special needs child. We can do trusts throughout during your lifetime for that grandchild or child. But oftentimes such a trust is created through a will. But there's a lot of things that you can do to make sure that your child, your grandchild, anyone has money protected for them, and yet they still get the benefits, the needs-based government benefits. So how do you know that? Again, see an elder law attorney. They can help you with that. Next, number 4, change to your assets. So let's say this life event has happened. Maybe you've sold your house, or maybe you bought a house, or maybe you've inherited money. Should you take a look at your estate plan to see, hey, should I change it? Well, definitely. Let's say that you used to own a house, but you no longer do, and you just want your assets to go to your child or your children. We might change up your estate plan to make it simpler, to say that there will be no probate on your death. Everything pays on death to those children. It's like a pay on death or transfer on death or beneficiary designation. They all accomplish the same thing. What it says is that on the death of the account owner, the people who are the beneficiaries of that account simply show the death certificate to the financial institution, and then they can collect the money from the account without any need for a legal proceeding, without a probate or any other estate administration. So that would be one reason to, go see the attorney, is to say, hey, the attorney will say, let's simplify your estate plan. Or if you bought a house, then we'll take a look at it and say, hey, how do we need to change your estate plan? If you just bought a house and previously you planned on avoiding probate, but now you have a house, there's going to be a problem. unless we put into place a transfer on death deed on that house. So again, it's a very simple thing to accomplish, but it usually requires an estate planning and elder law attorney to give you that counsel and guidance. Maybe you've inherited, and maybe the inheritance is substantial such that you might now be in a taxable estate situation. In Washington, our estate tax exclusion amount is $2.193 million per person. So if that's your situation, you've just inherited a good deal of money, now you're in a taxable estate, definitely see the attorney, because we will be able to give you advice about how to avoid paying any Washington estate tax. The federal estate tax level currently is over $11 million, so that impacts far fewer people, but it's the same sort of thing. There can be changes in your finances or inheritance or something that it makes it a good idea to revisit your estate plan and get some good guidance on that. Changes to your decision makers, and by that I mean your executor, your personal representative, your trustee, your attorney in fact. These things all mean something similar. Your executor, your personal representative, that means the same thing. That's the person who carries out the terms of your will. Your trustee is the person who either is managing the trust you currently have or will be in charge of a trust that your will creates. Your attorney in fact, also called your POA, power of attorney, that's the person that you've designated to be your decision maker during your lifetime. So that would be somebody you've designated under your general durable power of attorney or your healthcare power of attorney. When we prepare any of these legal documents, we recommend to the clients that they name somebody in the first position and then in the second position, and then ideally into the third position, so that we have the successor level, so that if something does happen to that first person, well, there's still two more people named. But people don't always do that. We don't always see, the three levels. So let's say that, there was only two people named and one person now is incapacitated, deceased, or whatever. They can no longer serve as your decision maker. Now your document only has one person. It's really not a good situation, because if something happens to that next person and you haven't changed it or updated it, your power of attorney, then you would be subject to a guardianship if you lose capacity. You might say, Lynn, you go through a lot of bad what ifs. Yes, I do. That's what an estate planning attorney does, because that's our job. We say, what if this happens? What if that happens? What if that bad thing happens? Because that's how you do estate planning that is robust and stands up to whatever life events happen. And I have to tell you, all of these sort of scenarios that I've seen, have seen them actually in person. So I don't just create bad things out of the air. They actually do happen. Hopefully none of those things happen to you. But hope and a plan are two different things. We want you to have a really good plan in place. So I think that we have gone through these 5 major life events: being moved to a new state, birth, marriage, death, and divorce. That's all one category. Changes in your health, changes in your assets, and changes to your decision makers. I'm not seeing any more questions in the chat. I am seeing one now, so I'll answer that. But do feel free to, reach out to our firm. We'd be happy to answer any of your questions. It's Elder Law Group, ELG Estate Planning. Or call us at 509-468-0551. Happy to answer any of your questions. All right, let me answer this question here. If one spouse becomes incapacitated, does the surviving spouse or adult child automatically have the power of attorney rights, or must they have legal documents? So that's a really good question. And it's very much misunderstood. So there must be a legally enforceable, durable power of attorney in place for anybody to have decision-making authority over anybody else. So definitely your adult child, if you want them to make decisions for you, you need to have appointed them through a power of attorney. I'm talking about financial decisions. Healthcare is another matter. I'll get to that in a minute. Let's say, no, I just want my spouse, I'm married, I just want my spouse to be able to make decisions. They can't. It might seem that they can because then maybe you're both on a joint checking account, so both of you can write checks or deal with the account. But have you ever tried to call on your spouse's credit card? You probably didn't get anywhere until you put your spouse on the line. Or let's say you want to sell your house and your spouse is incapacitated and you live here in Washington or in Idaho. You won't be able to sell your house without an effective, durable power of attorney. You will need to go through a court-ordered guardianship. Your spouse becomes a ward of the state, and then there's this quite complicated procedure to go through to even sell your own house because your spouse's name is on the house and your spouse is incapacitated. So that's really one of the most frustrating situations that couples see, is they think, of course, we're married, I can do anything, you know, sign my spouse's name. No, you can't. You can't do that. This is with what I'm talking about are financial situations. With healthcare, because not that infrequently people don't have powers of attorney in place, then most states have statutes that put into place the lineup of decision makers. So for example, because they want to, the healthcare providers want to avoid a guardianship. They don't have time. There needs to be somebody making decisions right now for the medical treatment, and that one person's incapacitated. Who are they going to turn to? Well, under the statute, they're first going to turn to, is there a guardian appointed? No, there's not. Is there somebody named as a power of attorney? No, there's not. Thirdly, is there a spouse? Yes, there's a spouse. The spouse can now make decisions. What if the person was single? There is no spouse. Who's next? Then they look at the adult children. And I'm not just saying eldest to youngest. They look at all the adult children. So you've got 4 kids. Nobody can decide. Nobody can agree. It's a committee. That's going to end up in a guardianship ultimately. So the idea with powers of attorney, number one, is to protect yourself, because you've named somebody that you trust who will make decisions that you would make if you could make them yourself, and to avoid a court-ordered guardianship. So don't just assume because you're married or because of the situation or that, somebody's going to be able to make decisions for you, because it's very possible that they can't. So that was a great question. Thank you, Jen, for asking that one. All right. Anybody else before we wrap it up today? All right. Thank you, everybody, for joining us today. Any questions again, or if you want to get a recording of this webinar, just reach out to us at elgwa.com is our website, or call us 509-468-0551. Again, thanks, everyone. Take good care.